Okay, so the written reasons are out in the Santos greenwashing case. And surprise, surprise, the real story is more complicated than the headline. The federal court dismissed ACCR's case against Santos, and ACCR has to pay Santos's costs. So yes, Santos won this round. The judgment's ACCR versus Santos, 2026 FCA 96. Santos is a major Australian oil and gas company. ACCR is a shareholder advocacy group. And this case wasn't really about did an investor lose money. It was more like if a company sells a climate story to investors and the public, can it actually back that story up? And that matters because these weren't random comments. These were investor-facing statements. Annual report language, investor day language, climate report language. In other words, the polished version, the version companies want people to remember. ACCR challenged three main buckets of Santos language. First, Santos calling itself a clean energy company and gas a clean fuel. Second, blue hydrogen being described as clean or zero emissions. Third, Santos saying it had clear and credible pathway to net zero by 2040. So basically the slogans, the labels and the roadmap. And this is where it gets very courtroom very fast. The court is not asking, do we think this sounds a bit spinny? It's asking, were these statements misleading or deceptive in the way ACCR specifically alleged? Which is a much narrower question. And that's often where these cases are won or lost, because a lot of people hear greenwashing case and assume the court is deciding a giant moral question. It isn't, it's deciding a legal one. Very specific words with specific meanings and evidence. And if the legal framing misses the mark, you can lose, even if people still feel the marketing was doing a lot. A big theme in the judgment is future-looking claims, targets, roadmaps, long-term plans. The legal test is basically, did they have reasonable grounds at the time? Not later, not with hindsight, not after the PR team has moved on. That distinction is boring and extremely important because climate targets are usually framed years or decades into the future. So the fight becomes, what did the company actually know then? What assumptions were they relying on? Were those assumptions enough to make the statement legally okay? And from the judgment, that reasonable grounds issue is central. This wasn't just a free pass for vague aspiration. The court looked at whether Santos had an objectively reasonable basis for the representations ACCR challenged. And from the federal court summary, one of the key findings is the court was satisfied that the representations were not misleading or deceptive in the manner alleged. Another part I found interesting is the audience question. Santos tried to narrow the audience, but the judge didn't accept a tiny insider audience idea. The judgment treats the audience as a broad and mixed group of investors, individual and institutional. That matters because if the audience is broad, the court has to think about what an ordinary reasonable investor would understand from the words, in context, not just what an energy lawyer or technical expert might infer after 3 coffees and a glossary. And the judgment also notes Santos gave these statements prominence. These messages were put out front and centre in materials like the annual report and the investor communications. So yeah, the court is taking the context seriously. It just didn't land where ACCR wanted. And now we arrive at my favourite part. The word clean. Completely normal word. Totally innocent word. Word that definitely never does too much work in corporate climate marketing. On the clean fuel issue, the court did not accept ACCR's reading in the way ACCR put it. The judgment's approach is basically people can understand clean in relative terms, not necessarily as zero emissions. And that gap between cleaner than something else and actually clean is exactly where so much climate marketing lives. That's the legal answer. Whether it's a satisfying answer is another question. Then there's hydrogen. This was a big one, because Santos used language like clean and zero emissions hydrogen in relation to blue hydrogen. And the court found a reasonable audience member would read that as a net claim, meaning gas-based hydrogen plus carbon capture and storage plus offsets, so no net emissions overall, not literally zero emissions at every stage of production. That interpretation matters because it changes what the statement is taken to mean in the first place. And if the meaning is different, the misleading conduct argument shifts too. Again, wording, context, audience. So the science argument and the legal argument are not always the same argument, and that's really the theme of this case. A lot of the public reaction is about science, trust, and climate urgency, which is fair, but the courtroom question was narrower. What would a reasonable person understand these statements to mean in context, and did Santos have reasonable grounds for them at the time? That legal framing doesn't always produce the result people expect from a public interest perspective, which is why this feels so unsatisfying to some people. The practical outcome here is not the court says everything Santos said is scientifically perfect. It's ACCR did not prove these claims were misleading on the legal framing they ran to the standard required. That's a very specific kind of loss. And in law, specifics are everything. So this doesn't mean greenwashing is now legal, and it doesn't mean companies can say whatever they like. It means this particular challenge to these particular statements failed. And yes, ACCR has to pay Santos's costs, which is not exactly the inspiring ending people were hoping for. Still, this case matters. It forced a major company's climate language into court and under scrutiny. It forced arguments about audience, wording, assumptions, and evidence into a legal test. And even though ACCR lost, that process itself sends a message to other companies. If you make big climate claims, there's a chance someone will drag the exact wording into court and make you defend it. That's not nothing. And it probably matters for future cases too, because this judgment is now a real reference point. Future challengers will read it. Companies will read it. Lawyers will definitely read it. And everyone will be looking at the same thing. What kind of wording survived here? What kind of evidence mattered? And where exactly did ACCR fail to clear the bar? So even if this feels like a loss for anti-greenwashing efforts right now, it's also a map. A frustrating map maybe, but still a map. So my takeaway, Santos won, ACCR lost, and the rest of us get a very useful reminder that in climate law, words like clean, credible, and pathway are doing a lot of work. So if a company uses them, the obvious next question is, okay, define it. Thanks so much for watching.